All right, we're back on the record on State versus Loyd. Mr. Loyd's present with his attorneys. The state attorney's office is present. The jury has indicated they have reached a verdict in this case. I want to remind everyone in the courtroom there will be no outburst regardless of what the verdict in this case is. The deputies are authorized to remove anyone who disrupts proceedings. If you find yourself losing control, please exit the courtroom. Is the jury ready? All right, let's bring them back in. State recognized presence of the jury.
We do, Your Honor.
Defense. Right. Ladies and gentlemen, I understand you've reached a verdict. Is that correct? Would you hand it to the deputy, please? All right, Madam Clerk, if you'll publish the verdict, please.
In the Circuit Court of the 9th Judicial Circuit, in and for Orange County, Florida, case number 2017 CF 826, the State of Florida versus Markeith Loyd. Verdict as to sentence count 1. We, the jury, find as follows as to the defendant Markeith Loyd in this case. A, aggravating factors. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The defendant was previously convicted of a felony and on felony probation at the time of the first-degree murder was committed. Answer, yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The defendant was previously convicted of another capital felony or of a felony involving the use of or threat of violence to the person. Answer, yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The capital felony was committed for the purpose of avoiding or preventing a lawful arrest. Answer, yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The capital felony was committed to disrupt or hinder the lawful exercise of any government function or enforcement of laws. Answer, yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Debra Clayton was a law enforcement officer engaged in the performance of her official duties. Answer, yes. B, sufficiency of the aggravating factors. Reviewing the aggravating factors that we found to be established beyond a reasonable doubt in Section A above, we, the jury, find that the aggravating factors are sufficient to warrant a possible sentence of death. Answer, yes. C, mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Answer, yes. D, eligibility for the death penalty. We, the jury, find that the aggravating factors that were proven beyond a reasonable doubt in Section A above outweigh the mitigating circumstances established in Section C above. Answer, yes. E, jury verdict as to the death penalty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt in Section A, that the aggravating factors are sufficient to warrant a sentence of death in Section B above, and the aggravating factors outweigh the mitigating circumstances in Section D above. We, the jury, unanimously find that the defendant, Markeith Loyd, should be sentenced to death. Answer, yes. Dated this 8th day of December, year 2021 in Orange County, Florida. Signed by juror number 158, foreperson.
State wish the jury polled.
No, Your Honor.
Defense wish the jury polled. All right, ladies and gentlemen, you're going to be asked a question by the clerk. It's actually, yeah, you're going to be asked a question. Please answer yes or no to that question. Madam Clerk?
Thank you. Do you, juror number 27, agree that each of the findings in the verdict form is yours?
Yes, ma'am.
Do you, juror number 215, agree that each of the findings in the verdict form is yours? Juror number 923, do you agree that each of the findings in the verdict form is yours? Do you, juror number 923, agree that each of the findings in the verdict form is yours? Yes. Thank you. Do you, juror number 781, agree that each of the findings in the verdict form is yours? Do you, juror number 927, agree that each of the findings in the verdict form is yours? 927. Thank you. Juror number 797, do you agree that each of the findings in the verdict form is yours? Do you, juror number 793, agree that each of the findings in the verdict form is yours? Do you, juror number 597, agree that each of the findings in the verdict form is yours?
Yes.
Do you, juror number 642, agree that each of the findings in the verdict form is yours? Do you, juror number 759, agree that each of the findings in the verdict form is yours? Do you, juror number 209, agree that each of the findings in the verdict form is yours?
Yes.
Do you, juror number 158, agree that each of the findings in the verdict form is yours? Thank you.
All right, the jury is unanimous. Ladies and gentlemen, I cannot convey to you all enough the gratitude of all of us here at the Ninth Circuit for your service in this case. These cases are extremely difficult. It's been a lengthy process. You have paid close attention. You've taken your time and worked as hard as any jury I've ever seen, and I thank you on behalf of all of us. You are discharged as jurors in this case. Now, jurors enjoy a unique privilege under our laws, which is that you never have to talk to anyone about this case. No one, lawyers, media, no one can make you talk about your deliberations or your decision. The decision to keep those private or not belongs solely to you. You are now allowed to talk about the case if you so choose, but that decision is completely up to you. So with the thanks of everyone in the Ninth Circuit, you're hereby discharged. You may return to the jury room. Thank you. All right, attorneys, Spencer hearing. That's the next step in this proceeding. I have the following dates for the Spencer hearing. Get your calendars out. January 14th in the afternoon, January 21st January 28th in the afternoon. Yes, sir. Mr. Lloyd, I'm not going to do your sentencing today. If you want to waive a Spencer hearing, you'll need time to discuss that with your attorneys. You will need to do that waiver in writing. All right. Mr. Lloyd, you are to address yourself to the court and not to the audience. All right, let's start with January 14th. State, starting at 1:30 in the afternoon. What's your availability?
Your Honor, I currently have a 3-week death case starting January 10th.
Which would put you to January 28th?
Correct.
Okay.
There has been discussions by the defense about wanting to continue that, and we would continue it several weeks ago. That was denied. But right now, I'm set to be in front of you.
Well, since I have Mr. Lloyd telling me he may waive Spencer, so what I'm going to do is tell me, if you were not in that death case, are you available on January 14th at 1:30?
If I was not, yes, I will be available.
Okay.
I'm not-
And how long does the state need for the Spencer hearing? How much time?
Not even a morning,
A morning?
at the most.
So you need an hour, 2 hours?
2 hours.
2 hours for the state?
Yes, Your Honor.
Defense, how much time do you need for the Spencer hearing if it goes forward?
Ain't nobody else testifying. I said I'm ready to see, y'all can somebody testifying. They done hid evidence, they done moved blood, moved bodies. I ain't no more testifying shit. I'm ready to get sentenced today. I'm not with none of this bullshit. Ain't scared of numbers going on in this courtroom. These people been trying to kill me. People done try to bring me for murder.
All right, why don't we remove Mr. Lloyd from the courtroom?
I ain't scared of nothing going on in this courtroom. Period whatsoever. Nobody. Never have, never will.
Let's get him out, folks.
Love y'all.
All right, how long does the defense need for the Spencer hearing? If it goes forward, just tell me. Mr. Lenneman?
Couple hours.
2 hours? So y'all need a total of 4 hours, all right. So January 21st is the best day I have to give you all 4 hours. State, any conflicts other than Mr. Buxman if you end up in an actual trial? Defense, any conflicts?
If it's in the afternoon, I will be returning from out of the country that morning, but I can get here in the afternoon.
Okay. The only other date I have is January 28th. I'm really trying to not put this off much longer.
I
I'd like to get
understand.
this done. So we can run late. I mean, if it's going to take a whole 2 hours, 2 and 2 is 4, it'd be 5:30.
Can we do it the 14th?
I can, yeah.
The 14th, I know I'm free, and my suspicion is Mr. Buxman will be free.
All right, defense, you ready to go on the 14th? Yes. All right, Mr. Lloyd's indicating he wants to waive Spencer. This is the day of the verdict. I'm going to note that he has said that. In order for him to waive Spencer, you will need to do that in writing, in which case January 14th would become the sentencing date. Parties are ordered to deliver sentencing memorandums to the court by January 7th. Well, no, I'm going to need it before that. It's holidays. Today's the 9th, 8th. How much time do you need to do a sentencing memorandum, State?
You tell us when you need it, we'll make it happen.
If there's a Spencer hearing, your sentencing memorandums are due on the 14th. If there is not a Spencer hearing, because Mr. Loyd waives the Spencer hearing, your sentencing memorandums will be due on January 5th. January 14th, beginning, I'll give you the start time as soon as I get with my JA, but it's either going to be, I prefer to start at 1 o'clock that afternoon and just run straight through. And I don't think there's any impediment to that from the note she gave me. Otherwise, I could start at 11 in the morning and break it up into the afternoon. So if Mr. Loyd waives the Spencer hearing, your sentencing memorandums are due January 5th, and his sentencing will be January 14th. I need an answer from him by the end of next week. If Mr. Loyd does not waive the Spencer hearing, then your sentencing memorandums will be due on the 14th, and after the Spencer hearing, I'll set the sentencing date. Any questions?
No, Your Honor.
All right, this court's in recess. Thank you very much.